Good afternoon, everyone, and welcome to this IANA webinar, Pandemic Unemployment Assistance, PUA, in the COVID-19 environment. Really appreciate you all making the time today. We know that you're busy. We know that you've got a lot going on, especially now. And one of the reasons that we're bringing you this special webinar is because of that. It's got some great information that's very timely, this critical kind of juncture for business. I'm really pleased to be able to bring this great panel together today. We've got two experts on this topic from our member company, OpenForce. Ryan Kelly is the CEO of OpenForce, and Deborah Stevens is the Chief Compliance Officer of OpenForce. And they're going to walk us through what, as I mentioned before, is a really critical issue and incredibly timely for a lot of you, especially if you're working with independent contractors, which many of us are. So without further ado, I'm going to turn it over to Ryan and Deborah.
Good morning, or perhaps good afternoon, depending on where you're at. I'm Deborah Stevens, the Chief Compliance Officer at OpenForce, coming to you with about a couple of decades worth of transportation, legal management background, tons of compliance and agency representation, and happy to bring this topic to you in this crazy world that we're in today. There's a ton going on in the world with this pandemic, and anything that we can do to provide information and share information with all of you to help protect yourselves and to protect the contractor world that you live in. We are excited to do that. We've got some good information. If you do have any questions, please make sure you get them out to us, because if you have a question, somebody else probably has the same one. So we like to get as much information as we possibly can out to everybody. So we are going to start, but I'm going to let Ryan introduce himself first.
Good morning or afternoon, everyone. My name is Ryan Kelly. I'm the CEO of OpenForce, and just by way of a little bit of background, OpenForce, as some of you may know, manages approximately 50,000 independent contractors per cadence or weekly or biweekly basis. And so we're seeing the independent contractor world on a scale that most don't ever see it. So Deborah and I are pretty familiar with what's going on, and we're hoping we can share with you today some best practices and just an overview of what we're seeing related to this very timely topic of the pandemic unemployment world within the CARES Act. By way of background, my background was I practiced law for about 14 years. All I did was represent transportation companies. That could be motor carriers, logistics providers, brokers, practically anything related to the transportation industry. It's a very small niche business. I think there's 10 of us in the universe, but there are some out there. And so that's a little bit of my background. And I eventually migrated into software and have been involved in compliance software for the last dozen years or so. And Deborah is our Chief Compliance Officer, as she noted. She was at one time performed a similar role for On Track, which many of you may or may not know is one of the larger transportation companies in the United States. So some familiarity with the legal world and some of the intertwinings of how legislation affects operations of logistics businesses will be shared with you today, and we're hoping everybody gets something out of it. So without further ado, we'll jump right in and take off from there.
Okay, so for today we're going to cover a few different topics. Ryan's going to chat about the CARES Act, which is actually how PUA, the Pandemic Unemployment Assistance Program, came to life. So then we're going to talk about PUA as well, the impact it is having on the 1099 workers. Also going to share some best practices for sharing CARES and PUA information, but doing so in a manner that actually helps you protect yourself and your company from taking a hit during this unemployment claim world that we seem to be living in right now.
So I'll jump in here, and what we wanted to do is make sure that I think everybody's aware of the CARES Act, but we thought we'd give you a little bit of an overview on how we arrive at today's topic. And so as you can see, the CARES Act is actually, I think that's supposed to be $2 billion in relief to American families and businesses. But it's an enormous financial commitment on the part of the federal government to try and get us through the coronavirus downturn in the economy. It's an ongoing work of art that is a massive act. I mean, the act itself, I can't even remember, it's hundreds of pages long, and it really is hard to unwind all the relief that's in it. But if we run to the next slide, you'll see I tried to break this down a little bit into the major points here. So under the CARES Act, you really have four primary categories of benefits that kind of spring out of the CARES Act. Before we jump into like these specific areas, let's talk a little bit about who the CARES Act applies to. It applies to businesses with 500 or fewer employees. One note about this, if anybody on the line is owned or private equity owned, please be aware that there are private equity aggregation rules that may also apply. What that means is if you're private equity owned, they might look at the ownership of your entire private equity group as related to you rather than just your own company. So it's a little nuanced, but be aware of that. But businesses with 500 or fewer employees, independently owned franchises with fewer than 500 employees, and some other lucky specified businesses that they kind of swept within the act, which includes like nonprofits and tribal businesses and some other specified businesses. But really, it's meant to be a small business act. As we've all seen on the news, didn't necessarily pan out that way with some of the franchises and other things like that. But nonetheless, that is the intent, and it does appear that the vast majority of the act did go to at least those small and medium-sized businesses. So just looking at the kind of topics and the four main branches of the CARES Act, as I said, four categories of main benefits. The payroll protection provision, which is the PPE. We'll talk a little bit about that. The EIDL, which is basically a disaster loan, and that was already in place through the SBA, but they made some additional provisions of that. So basically, these two things on the left you've read a lot about, seen a lot about. These are the things of applying for payroll protection, how much counts, how much can you get back, how much is a grant, all those types of things fall within those first two branches. There's tons of stuff out on the internet about that. Then on the far right, you can see I just kind of listed other benefits as a whole. So there's a fourth branch, which has a whole bunch of not very common scenarios where you can get other benefits. And we won't really be talking about those specific provisions. What we're really going to focus on is the orange branch here, which is the pandemic unemployment assistance provision. And really that is one of the main provisions of the CARES Act that really introduced a whole new set of relief that we've never really seen before, and some things that use independent contractors should be aware of. So let's break that down. So now instead of these four branches, we're just going to focus in on the one branch of the Act called the PUA, or as I call it, the PUA to try and make it sound better. The PUA here, if we click to the next slide, let's see here. So within this branch, you can see you've got a little bit, once again, breaking it down into three additional branches. And so on these additional branches, you've got the standard unemployment. So this is what we're all used to, and it's been in place for a long time. And you may ask, well, why is standard unemployment now entering the play here? And the reality of it is, it's entering the play under the PUA Act because there were some unique changes that the federal government implemented, even with respect to standard unemployment, all the things that we're used to for employees. And mainly it relates to the branch on the far right, which is they added, the federal government added an additional compensation layer under the CARES Act, under the PUA CARES Act. It added an additional compensation layer, and that was called the Federal Pandemic Unemployment Compensation Provision. And that, you may have seen, adds approximately, let's just say roughly, because it depends on time frames of when you're talking, but about $600 to the benefits that one can receive if you're a standard employee. So in the old days, what we typically think of is somebody was working for a company and they were laid off. What they would go down and apply for unemployment, and they would get a standard benefit, usually set by the state levels, and they have various levels. And let's say that's $400 per week. So they get $400 per week. Under the branch on the far right, which says new, you can see it says Federal Pandemic Unemployment Compensation. It added an additional $600 to that benefit, which is important, and we'll talk about that in just a second. So if you look at this, you've got the standard unemployment, and then you've got the addition of this $600 kicker. And for the rest of the time, I'm going to call it a kicker just because it sounds a little bit better and it makes it clear what it is. So that's the $600 kicker. In the middle, you've got something completely new, which Deborah's going to talk a lot about. And this was really the fundamental change. In addition to the kicker, they also added the ability for independent contractors and self-employed individuals to qualify for unemployment assistance. And as most of you may know, that is something that we really have never seen in the United States before. Virtually, and just to be clear, unemployment is pretty much uniformly run by the states rather than the federal government. So now you have the federal government coming into play and actually creating a provision that is going to allow for specific groups, independent contractors and self-employed individuals, to be funded for unemployment by the federal government rather than the state governments. Now, this created a lot of confusion because no one really knew how to administer this. The federal government does not have an agency that's suited for this. And Deborah's going to talk a little bit about their resolution to this and how they instructed people to go about getting this pandemic unemployment assistance for independent contractors and self-employed individuals through the federal government funding when the federal government has no agency to do it. So it's important to know, though, if you look under the PUA branch of the tree of the CARES Act, you've got these three key provisions, and we've got a little description down there for you for each of them. But the two new ones are the two on the right. The one on the left is standard, but it's adding the branch on the far right, which is the $600 kicker. So if you can understand all that, we'll move on. Just real quickly here, a lot of people have asked us, go ahead, yeah. So a lot of people have asked us, and I just wanted to include this. This is mainly for everyone's reference when you get out. A lot of people say, well, how much unemployment can an independent contractor or a self-employed individual receive? And you can see some of the figures here. And just as a general, look at this, you can see the average across all states is about $387, or I call it $400 per week, is the average according to the Center on Budget and Policy Priorities. And so that amount is, in and of itself, $400, pretty tough, on people to live on, and I think that's why they implemented the $600 kicker. So if you're a self-employed individual under the Pandemic Unemployment Act, you'll receive your state guidelines, which in this case we'll use $400 as the average. And on top of that, from March 27th through July 31st, if you were eligible, you will also receive the $600 kicker per week. And that's where you've heard it bantered around. You're getting about $1,000 a week under the PUA Act as an IC or an independent contractor / self-employed individual. And so once again, these numbers are just here for you guys to be able to kind of see how this shapes up mechanically from a number standpoint and know what you're up against. And we'll talk a little bit about what we mean by what you're up against. So with that, I'm going to kick it over to Deborah. She's going to really take a little bit deeper dive into some of the specific provisions and the mechanics of it.
Thank you. So as Ryan explained, this is a brand new program. The first time ever ICs, independent contractors, have actually been specifically included in being eligible to receive unemployment coverage, and that's via the CARES Act. Because the way that the program was rolled out, and it was rolled out so rapidly, there's a lot of muddy water in there. So the CARES Act is a federal act. Unemployment claimants who believe they are covered can file. The problem is it's a federal program, but there's no federal agency to actually manage these claims. So folks are being directed back to the state to actually file, and the state doesn't really have a mechanism to properly process these. They do now. Things have been put into place, but in the beginning, a lot of things were not happening the right way because it's a joint federal-state program, but the guidelines, because it's brand new and it was pushed out so rapidly, it wasn't clearly defined how it was going to work and when it was going to work. So there's been a lot of misnamed folks in there, and this is kind of what we want to try and help you with today. Talk about how you can protect your business and protect yourself from being the one who is actually having to fund the unemployment, because it should be coming through the federal program and not through your agency or through your company. So it does not reference, the Act does not reference contribution by an employer or a contracting company. And as it pertains to the IC, it's actually, again, supposed to be a federally funded program, but they just didn't put it out there very well to make it easy for everybody. So what's hard to explain about the PUA, sorry, it's a little slow in the transition there. The Act does not specifically state the mechanisms and the processes that would utilize a state unemployment agency to file the claim. It doesn't tell them how to do it. So what we're finding a lot of our clients, they're getting unemployment claims coming in because the independent contractor is actually naming them as the employer as opposed to putting in their EIN or their own social security number. So the way that it should work and the possibility for it to work the right way is for them to actually apply under the EIN or their social security number, but they're calling the state agency, and that's not the direction that they're being given. The other possibilities, they're still requiring the contracting company names to be listed, but then that turns into a battle for you because then the benefit is coming from you versus from the federally funded program. So because this is so unclear, the main concern that we have here is that the independent contractors are actually naming the contracting companies on their paperwork.
Yeah, and Deborah, one of the things that we've talked a lot about here is, if you think about it, there are really two possibilities. When an unemployment claim when an unemployment claim for one of your independent contractors that you're contracting with hits your desk, there are one of two choices if you've been named as the employer, the putative employer in this case. And that is, one scenario is that the independent contractor, self-employed individual meant to name you as the employer and intends to say that they've been misclassified as an independent contractor when they believe that they're an employee. That is one possibility. The second possibility is what Deborah was just referring to, is that they did not intend to name you as an employer. What happened is they went down to their state agency, and the state agency, having no way generally to process claims for self-employed or independent contractors, it generally, and they're finally catching up in the last few weeks here, we're always naming an employer, and it was part of the form and it was part of the process. Some states, these are broken into various states, some states still are requiring people to name an employer. And when they're required to name an employer, once again, then they have two choices. They can name a company that they're contracted to, or they can name themselves. And the problem with naming themselves is you need an EIN in a lot of these states and a tax identification number of that employer. And a lot of these people don't know, and they might not even have the means to list their own tax ID number other than their social security number. So there's multiple problems cascading through this as these independent contractors and self-employed individuals attempt to navigate that kind of maze of regulations and agency work. But I want you to keep in mind, really what we're talking about today is trying to sort those into the two buckets. One bucket being the people who actually wanted to name you in a misclass claim, and the other bucket is the people that simply wanted to make an unemployment claim under the PUA Act and somehow inadvertently found you as the employer.
So let's talk a little bit about some of the best practices to follow during the depending on what stage of the game that you're in, essentially. So there's a pre-claim period, which is the best spot to be in. I'm going to talk about that, and we're going to talk about what happens when it's been filed, and then if you were inadvertently named because they had to name somebody, what you can do to actually defend that filed claim. The best place you want to be in actually is the pre-claim stage, and that's today. If you haven't already received paperwork and you have contractors out there or you have folks out there that are talking about filing, the best thing you can do right now is get in front of them before they ever file and assist them in actually filing it properly. And there's some good and legitimate reasons why you want to share this information. First and foremost, you want to prevent yourself from being named. It just becomes a process and something else that you can go to. But the real solid reason of having this communication with them is to actually get them to have access to these benefits quickly. There's a lot of delays that will happen if they go through and they file it improperly. The proactive measure actually puts you in the driver's seat. It enables you to guide them through the process so they get their benefits, you don't get named, and that's really what you want to try and do. You want to get yourself out of that game. You have to be careful, though, because if you're having these conversations, when you're having these conversations, do it in an informational type of way. What you don't want to do is come across, because we've heard of this happening as well. Somebody goes out and has a conversation, and it's not what they said, it's kind of how they said it. And then there's other claims of, that you're being coercive or threatening, or you're telling somebody that they can't follow through and do what the federal government said that they've had the right to do. And remember, the agencies don't know what they don't know. So you might have a conversation with a contractor, and they're going to tell you, well, I went to them and they said that I had to name you. Again, it's a very confusing program, the way that it was rolled out. It's a federal program with no federal agency to handle it. So they're kicking them back to the state, and the state doesn't really know what to do with it either. because it's a federally funded program. So very early on, it was very confusing. I think Ryan's right. It's better today, and there's a lot better handle on how to do it. But again, it's just very important. Get in front of them, and there's nothing wrong with telling them, hey, when you go through, put your EIN or how to name it, and explain to them what's going to happen. If they file it the wrong way, it's going to go back to you. You need to contest it. And everything is a delay. Once it's contested, the money's not going to come to them, and they need the money. That's why the program is out there. It's a huge benefit that the federal government actually put in place for these folks. So you have two goals: help your folks get what they're entitled to do, and then also to keep yourself out of it.
One other note on this, and we've seen a lot of this with our clients that use OpenForce. They've asked us how they should be looking at this. And while we're not a legal services provider, because we're seeing the best practices and what people are doing, we've really broken it down into two groups. One group is clients who really aren't losing business. As you guys may be aware, there's a lot of people in the logistics business right now that are actually doing better than they were before. Not all, of course, but it is an essential business in many ways. And so, in a strange way, companies that have seen an uptick or have stayed steady, that might be a tempered message, and maybe you don't need to be as proactive in the messaging of letting people know of this benefit. Once again, this is purely up to you and your counsel, but in looking at it, you may make a choice to say, hey, we're in no different situation than we were 3 months ago, and the risks are no different, and you may choose to take one course. A second group, and I think this is the group that we primarily were seeing an uptick in, is people whose businesses were significantly affected. So these would be motor carriers, brokers, other people whose business was significantly affected, and they knew that the independent contractor, owner-operator workforce that they had underneath them and were contracted to them were going to receive less work. So they knew they were at higher risk, and that could be they reduced it across the board, and so they knew there was an uptick across the board, or maybe with a specific group or a set of drivers that were contracted with them. They knew those specific drivers would be facing significant losses in business. Those are the groups that I think Deborah's talking about that really consider what messaging and being proactive with those groups, because if your risk is at an uptick and these people might be headed down to actually make a claim, then the messaging really kicks in on how you make that messaging and being careful, but getting them directed to the aid that they so desperately might need, which is a great thing for everybody, and that's the point of this, but also getting them to the right place, and as Deborah said, getting them to file it so it goes through the fastest, because many of our clients are being faced with a hard choice. They want the independent contractors receive aid, but they can't set a precedent, so they're contesting anytime they're named as an employer, which then, as Deborah said, delays the whole process for the IC.
So just recapping again what to share, have these conversations with these folks. Let them know if they file improperly or don't fill out the paperwork the right way, it's going to result in a contested claim because you should contest it. Again, it's as Ryan said, it's a bad precedent to set for you to just process the paperwork through, even though you understand that they need the benefit. Misnaming the employer, it also delays any applicable unemployment award if they don't process it the right way and they don't properly reference the PUA benefits that they have. It's going to take more time for it to actually figure out, and ultimately, it may limit the amount of benefit they're awarded if they don't do it the right way. So, earlier in the slides, Ryan shared the amount of money that's out there, but they have to actually file it and put it through the right way to actually be entitled to all the benefits that they should have. But at the end of the day, you're going to get named anyway because that's what happens. So you will get the paperwork. The most important thing you can do is be responsive, but be responsive and timely with your response. Again, the states are very confused, and for the states on how to handle some of these things, but for the states that aren't confused and aren't very contractor friendly, they will automatically just find against you. So they'll use a reason, and if it's late, then it's late. Then you're going to get named as the employer. Your response should actually include verbiage explaining the IC status and request for a proper adjudication of the claim under the new federal benefits program that's put together. Explain the claimant was an independent contractor entitled to coverage through the CARES Act if they meet that criteria. If it's determined that the claimant is not entitled, you can remind them then that since the claim was put through by a self-employed contractor, coverage under the state is still not warranted, so it still shouldn't come for you, and just flat out request for it to be dismissed because you're not the employer, and recommend that they actually refile as a self-employed entitled to coverage underneath the PUA and the CARES Act. Will this work? I think we've already seen it go both ways, but you do need to go through the process because you have to protect yourself, and setting precedents of being the employer and just letting it go through is not going to be good for any of us.
Yeah, and then this is an interesting point. So what we're really seeing across the practices, and you guys in working with your own counsel, is in the response. So these are the agency responses to, the responses that you're making to an agency notifying you that an unemployment claim has been made, naming you as an employer. And really, it is almost pleading in the alternative. What we're seeing is a lot of people saying, first offense is that this was misnamed under the PUA Act and that this person actually qualifies directly under the PUA Act. And if, in fact, this is meant to be a PUA claim, you're named inadvertently. That's kind of step one. Step two, in the event that you are intentionally named and they are alleging misclassification, then deny, that because of A, B, and C, and then you're setting up your standard defenses. So it's really making sure that both of those find their way into the response. We have talked to a lot of people, and this is a rather interesting nuance, and Deborah noted it in the slide here, but in some ways, you're also notifying the IC to make sure that they understood that, because typically they're going to get a copy of this response, and it's letting them know too that, hey, if that's what you intended, you may want to consider that. So it actually has two parts to it. I think one of the risks that a lot of the attorneys we've talked to about this is, once again, if you're doing this in the pre-claim stage or in the post-claim stage, the reality of it is it is a risk, because especially in the pre-claim stage, you don't want to be seen as dissuading them from seeking relief or actively discouraging them from making a claim. But at the same time, you want to make sure they get to the right place, and that's where this tension continually arises.
So even if you're filed against, remember it's not over yet, and there's nothing preventing you from now reaching back out to your business partner, whoever that person is. So you didn't get to them before they filed, or you got to them and they didn't get it, so they filed anyway. Hopefully you just didn't get to them, because then you can get to your business partner, contact them and explain to them, look, you got this paperwork, remind them of the information. If you did get to them beforehand, remind them of what you shared before. And if you had not gotten to them beforehand, walk through the same process and explain to them the program and how it works and how they can actually get their money, and suggest that they actually go talk to somebody to make sure that they get. Again, you don't want to come across as coercive. So if somebody's filed for unemployment, it's because they want money, and they're going to see that you're going to fight it. It could get into somewhat of a less than pleasant conversation. But suggest that they actually go out and talk to somebody. And hopefully it's the first bucket, and they just didn't know what they didn't know, and they filed it wrong, and you can get them to just go through and withdraw the filing and refile it the proper way, and cite the reference to the PUA and the CARES Act so they can quickly get the benefits that they're entitled to.
Of course, one of the risks that is always lingering out there is that they go to see counsel, and the counsel actively encourages them to get involved in a broader claim with additional people, and that is always the risk. And these are the hard weighing circumstances that you have here. On one hand, you want to make it clear that relief is available to them, by taking the correct route. But that really is somewhat offset by potentially getting dragged into something that really inadvertently you were never intended to be dragged into. So really hard choices all around. And that's why we're urging people to, talk to the others who have been, through this a few times, work with your counsel to determine where you want to steer that ship through a little narrow passageway, because a lot of times there are hazards on both sides.
Absolutely. I like to reference them as accidental lawsuits. Workers' comp and unemployment are the two heat-sinking missiles for misclassification issues. So, but again, I think the biggest thing you can do is properly communicate as much as you possibly can the benefits that are out there, how they're supposed to work. If you're sharing information and you're coming across as their partner, they're going to take it that way, and hopefully they'll follow the paperwork the right way. You won't have to deal with the legal battle with it, and more importantly, they're going to get their benefits, and they'll get them quickly, which at the end of the day is the goal of the program. So what else can you do? again, talk to counsel whenever you're establishing your programs, or in, more relevant to this, if you have something come up and ask their advice. Try to follow the ever-changing legal landscape to keep your model defensible. I've got 15 plus years living in the agency and courtroom claims in the state of California, so very well versed on that. And the phrase that I like to use is your best offense is to have a solid defense, and manage your independent contractor model, program in the most defensible manner popular as you possibly can. Educate your employees, and depending on the state you're in, but utilizing a third-party administrative type company to add a layer in between you and your partner. Lots of legal ground to be gained in a lot of the agencies' hearings, and there's a huge administrative burden that comes across with managing a large contractor program. So utilizing a third-party administrative company also significantly reduces the administrative burden of the enrollment process, recruiting, settling, contract management, compliance issues, insurances, and things like that.
One other note on this is, as you guys all kind of wandered through this, it's funny, having practiced law for 14 years, I can tell you everybody, lawyers all have kind of their niche and will give you their views from their perspectives. As a transportation lawyer, I was, very much inclined to see things through that lens, and how we might be able to leverage, some of the federal transportation laws to actually help mitigate the IC misclassification problems. And I think we're seeing that already today in California, as most of you guys know. That has actually been helpful in some of the early mitigations. Whether that will pan out long term or not, we don't really know. But my point is, you can get perspectives from multiple different legal providers too. And that's really something important. Is you might get a transportation law perspective, you might get a more of an employment or misclassification law perspective, and then some people just have their own local attorneys who maybe are just more general practitioners. And those are the three groups that we really see from a legal practitioner standpoint relative to most transportation companies, which might be kind of their standard local business attorney, their transportation attorney, and their misclassification/employment law attorneys. And so once again, just be aware that not all attorneys see through the same lens, and sometimes it's good to get different perspectives. Ultimately, you have to make that business decision from their advice, but sometimes it is helpful to get multiple perspectives. So I think with that, we've got a little bit of time here, and we'll turn it back over to see if we want to get some questions in the Q&A going.
Let's do that. First of all, Ryan and Deborah, thank you so much. That was great. I'll say this: I've read a lot, and I've listened to a lot on these topics, and you've done a great job of cutting through a lot of the really confounding stuff and giving us sort of the real meat in nice, clear language that you don't have to be an attorney to understand. So for that, thank you very much. And great experience, leveraging that experience to give us this insight. So really appreciate it. We've got a few here, and I think a lot of them they're probably riffing on similar things. I think what I'm seeing in a lot of these is folks are really concerned about they really want to help what they can to support their IC community, but they all seem really concerned about misstepping and basically giving a misclassification case some fodder. So there seems to be a little bit of a theme, not surprising, considering the climate that we were in leading up to the pandemic. And I think some of this is basically asking you to kind of reiterate some of what you said. But here's one. What are some tips for sharing information about the PUA while still maintaining appropriate separation? And their rejoinder is, we want to help, but we don't want to seem like we are employing them, basically. So that's the first one. So some maybe recap some tips for sharing information appropriately.
Yeah, this is kind of an interesting thing, and we're more than willing, if anybody has this need. What we've done, just as an organization that works with independent contractors, because really our software platform is used for both our clients are not only our contracting companies, but also the ICs that use our platform. And so what we did is we put a toolkit together for independent contractors, an online toolkit, and it has all the resources and explains how to do this and how to go about it. We're more than glad to share that link with people so they can share that out to say, here's a resource for independent contractors. There's other ones too, but that's a really good way to do this, in my opinion, because especially if it's even keeled and you know the place that you're sending them is even keeled and it has the right balance, or what you want to use as a right balance. But there are a lot of those resources, and then it's just simply saying, hey, you know what, to our independent contractor, we know this, you've been hard hit by this. Here's a resource where you can see the tools available to you, and that way you're not doing it. It's coming from a third party, and once again, this is just another resource for them to look at. We've tried to strike the balance in our toolkit between recognizing and, once again, having both sides of the equation be clients of ours. We're trying to strike the right balance in there. This is not, and I think you guys are, the audience and from everybody we've heard, people understand this is not about like avoiding claims and things like that. People, all of our clients have expressed to us, they want to do the right thing by the business providers that they've worked with for so many years. And I think that's finding that right balance. So I would suggest as a net, find a resource like our toolkit or some other third-party toolkit that you can then just refer them to, and it has all the information in a very digestible and usable manner for the ICs, not legalese, but enough where they can understand it. Any other thoughts on that?
No, I mean, the concern is completely valid, though. It's a fine line of sharing information, or are you training them, right? And you have to figure out how to find that fine balance. So sharing that information from a third party, whomever that third party is a little more digestible because you don't come off like you're speaking to your employees.
No, that makes great sense. And I think, as I mentioned before, we're going to send out to everybody that registered a link to the recording and the slide deck. I will also throw in a link to the OpenForce toolkit for folks, because I think that's a great resource that someone can either use directly or maybe build on to be able to say, here are some resources from industry experts that you may find helpful. So that's wonderful. Here's a question, and you alluded to it a little bit before. And I think we know who some of the challenging environments are, but it'll be this sort of speaks for itself. Are there states that are a little further along in sort of understanding the nuances of the PUA when it comes to IC filing for unemployment?
There are. In fact, we'll get over to you another link that you can send as a reference for everybody on the call today. Oddly enough, the National Realtor Board has a really good set of data and information, and they created a state-by-state breakdown of what's happening in each state. It's a really good graphic. But we'll try and get you that link too, so everybody can have access to it. It's really hard to find. Like if you search on their website, not easy to find. But nonetheless, it's a really good thing where you can just click on any geography and it tells you what agency is doing it and where they're at, and it gives a little summary, which is really good, and they've been keeping it up to date. So once again, this is about finding those types of resources. But I think there's a few other ones too that are out there where people have been keeping them up to date. The other thing that you can do is you can take some of the tougher states. So think about like California and New York, of course. If you go to their state unemployment agency, whatever that state is that you're looking at, almost all of them now have a PUA page on their site. And so it's really easy to check and see how far along they are. And like I said, I can't remember I think it was 12 states last time I heard that there were 12 states still requiring somebody to list an employer, just because their systems are not equipped not to have that. And so that's creating some of these problems even today. But I think most of the larger states have jumped that chasm and have, like California and I think New York have now put in place measures recognizing that they've had a large influx of claims by these people. So they've actually got a lot of it straightened out. But I would just tell you, and on this resource that we'll send out, it actually has that. If you just click on it, go to that state agency, or do like we're in Arizona, we're based in Arizona, Arizona unemployment PUA. If you type that in, the reality of it is you're going to find your local page, and you can immediately see how far they are.
No, that's terrific. Yeah, I mean, because I know that we've had a lot of members that have had challenges in both California and New Jersey, and so we've been really supportive of our members and supporting the independent contractor model, and so that's super helpful, that info. I think we've got maybe time for one more. We can sneak it in here. Here's one. Are there things, and this, they're all kind of riffing on the same thing, but I think you guys, you've really kind of uncorked a nerve, I think, for folks, because they, again, really want to help, but they don't want to do the wrong thing. Here's one. Are there things that we can do to document what that we are helping our ICs and kind of get out in front of the potential misclassification claims? So are there any other things that folks can do to sort of document that they're doing the right thing and they're not employing the ICs?
Well, I think if you're sharing information from a third party, I think if you self-create your own material, I think you kind of start muddying up those waters a little bit. But if you're sharing information coming from a third party, then you're just doing that. You're sharing information. And I mean, in my opinion, my practice has always been really not to have a whole lot of documented anything with your contractors, because then that actually lends to an employee file type of a situation. But again, if you're sharing information that's coming from a third party, you're not sourcing it, you're passing it along. And then if questioned, then you can explain what you've done. I think that's probably a pretty safe approach to it.
Yeah, and I would agree with that. I think, I always tell people, back when I was practicing law and even today in the best practices world and just thinking about this, as we all know, these are vendors, right? And if you think about what you do with other types of vendors who are vendors to your company on a regular basis, that's the same thing, is that you would want to have the same dialogue with these people that you have with other types of vendors that you deal with on a regular basis. So if you're sharing information on what can make your business successful with other people and having that dialogue and a minor, I would think of it along the same lines. It's just really tough. I think this is where everyone, is trying to find that right balance, is wanting to be helpful, but at the same time, not wanting to get into training or supplying information. And so, once again, I would say this: be purposeful about it. Make a plan. We're still in the throes of this. Make a plan. Check with your counsel. Get something done and say, hey, here's what we're going to do. Here's the messaging and communication kind of theme that we want, and here's the only ways we're going to propagate that message out. And that should be propagated within your organization, because as we all know, it's the person out on the dock or the person out, at the office that's dealing with the ICs on a day-to-day basis. Those are the people that you probably have the most risk with. And the ironic thing is, those are the people that want to be the most helpful. And so once again, you just need to make sure your entire organization understands what your messaging is.
That's a great way to wrap up. You gave us, sort of 5 bullet points for success there. Folks, I really want to thank you both for sharing all that great experience and the hard work it took to digest all of that information down into something that a lunkhead like I can understand. So thank you very much for that. We really appreciate you spending time with us. For everyone else, if you want more information and resources around this issue, please check the coronavirus resource page at intermodal.org, or give us an email at info@intermodal.org. Also, if you want to have any follow-up questions with Ryan or Deborah, again, hit us up. You can either send information to info@intermodal.org, or just send it directly to hal@intermodal.org, and I'll pass it on. Great resources, a lot of really great information. So we'll be looking for getting some information out with some helpful tools to people as well. Again, I want to thank our year-long sponsors for their support of IANA. They go above and beyond to help us out, and we really, really appreciate all the work that they do to help support our programming. And with that, I am going to say thank you to everybody for their help today, their time today, their attention, and please, as always, stay safe out there.